Okay, great. So this is Jessica McGrew of the McGrew Law Firm, and she will be walking us through wills, powers of attorney, healthcare surrogacy forms, and other estate planning and potentially some small probate issues, nothing really complicated. And I hope you all enjoy what she has to say.
Thank you, Colleen. I want to start by going over some of the documents that are usually left out of the conversations about estate planning initially. Um, the main three I'm going to talk about are a living will, which is also called an advance directive, the healthcare surrogate designation, and the durable power of attorney. I want to start with a living will or advance directive. This is a document that you prepare now during your full capacity while you can think through all of these decisions. And you're giving directions to someone, they're just going to be carrying out. So this is not a document that empowers someone else to make decisions for you. It is a record of what your decisions are that you've already made. Under Florida law, for a living will to apply at all in the first place, you have to be in one of three underlying situations. The first one is that you have to have a terminal illness. The second one would be that you would be in a persistent vegetative state, which most of us call a coma. And then the third situation is if you are in the end stage of dementia or Alzheimer's or a like illness. So that's the baseline. In order for this living will to even apply and be carried out, you have to have one of those three conditions. The second checkpoint is that the condition you have has to be beyond any hope of medical improvement. So if you're placed in a medically induced coma so that some treatment can be done and they're going to bring you back, then nobody is going to be permitted to carry out your living will in that circumstance. So the decision as to whether there's any hope of medical improvement has to be made by two medical professionals, one of which should be your attending physician or primary care doctor. So again, you have one of three underlying situations. It's beyond any hope of medical improvement in the opinion of two medical professionals, and you lack the capacity to give a decision to your doctor about treatment, then this document applies in very narrow situations, which are basically an intervening event happens that could cause the end of your life. So for example, you may be in a coma and your kidneys fail and you need dialysis. So on your living will, you're going to give instructions. If I'm in a coma and my kidneys fail, and it'll say, do you want dialysis? And you just check yes or no. And the person carrying out your living will follow the directions that you've recorded at that time. Now, of course, if you're in the situation where you have a terminal illness and you're perfectly capable of giving and voicing your decision about whether to treat these intervening events, then your decision is going to govern. No one's going to take out a living will and say, no, 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 you told us this is what you want. You can absolutely make those decisions. So the goal of this is if you're in a situation where you cannot give consent, nobody is guessing at what you would have wanted. It's already been recorded. So in a living will, you normally will list at least two people who you're going to put in charge of carrying out your living will for you. Usually your spouse would be the first person listed, but they do not have to be. Then you'll list an alternate, and it's really important to give phone numbers and contact information for both those people in the document. So a broader healthcare document is often needed. Again, the living will is very narrow. So we usually implement a healthcare surrogate as well. This person is empowered to make any healthcare decisions for you short of end of life treatment if you're unable to make those decisions yourself. So again, most people will name their spouse first. That's usually who the doctors will look to in an immediate and emergent situation. So it's good to be consistent, but you do not have to. You can name someone else. You should name a backup, and their contact information should be accurate and correct in your document. Your healthcare surrogate is going to be permitted to sit in on doctor's appointments with you, to sign consent forms if you are incapable of doing so yourself. I should preface this, all of their powers are conditioned on your incapacity. So while you're welcome to permit anybody to sit in with you, they can't insist on attending appointments unless you are incapacitated and they're named in this document. They also will be able to obtain medical records for you, obtain prescription refills. There's a general HIPAA waiver usually in there as to your medical information and that person. And of course, then they can participate in conversations with all of your medical professionals on your behalf, and continue to make decisions on your behalf. The third document I want to talk about is a little bit broader. So it usually, a durable power of attorney will contain healthcare provisions. It's important to make sure that your documents are consistent. So if your durable power of attorney is given to your spouse, they should also be named as the first choice for your healthcare surrogate. We don't want to have multiple people coming forward with powers and trying to battle out who actually gets to make decisions. So keep consistency in the people you've named. A durable power of attorney in Florida is an extraordinarily powerful document, as in other states. Unlike many other states, it cannot be conditioned on incapacity. So if you sign a durable power of attorney, it is effective immediately. And in a general power of attorney, which is usually what a lot of estate planning attorneys will advise, give every power that you might possibly have over yourself or your property to someone else in this document, so that if you become incapacitated, they can do everything that you would want them to be able to do. This general durable power of attorney will give them just that. They can make healthcare decisions for you. But also if you have stock in a company that permits you to vote, they can vote on your behalf. They can access your bank accounts, even if they're not a co-owner or a signer. If it's in your name and they have a power of attorney, they can access it. They can pay your bills, they can do helpful things, but this person can also sell your house, mortgage your house, clean out your bank account. I like to make sure that people know that, because even though it's an important document, you want to be very careful about, first, the person you're entrusting, and second, whether or not you hand over this document to them. A lot of times when I meet with clients, we'll do a durable power of attorney, but if they don't have a spouse or another person who's their life partner, we will say, tell your person, if anything happens to me, here's where my documents are, they're all in order, and you're my person, but don't hand over anything to them. So it's important to keep this document safe. It is basically a key to everything you own. But that said, we think it's important because one of the most expensive things that can happen to us as we age and as our memories go is guardianship. And if you have a durable power of attorney in place, it is very unlikely that a guardianship would be necessary, and therefore unlikely a guardianship would be granted to anyone. So guardianship is a court process where someone gains control over your person and over your property. They do so under court supervision, so there is an added protection, but it is an expensive process. And oftentimes the person you would have wanted to be in charge may not be the one appointed. So that's why we really recommend durable powers of attorney be put in place and that a healthcare surrogate be named. It's your decision whether you want to put in place a living will or not, but those other two documents are usually strongly recommended.
What about a pre-need guardian appointee document? Do you also recommend those even if you have a power of attorney, or do you recommend one or the other? And can you explain what a pre-need guardian is?
Sure. So a pre-need guardian appointment is you making a decision now that if for any reason, perhaps the person you name in your
So pre-need guardians.
So a pre-need guardian would be necessary as it's kind of necessary as a backup. If the person you've named in your durable power of attorney were to predecease you or become incapacitated themselves and unable to act for you, or heaven forbid, be convicted of a felony and be unable to act for you for any number of reasons, a pre-need guardian can be a backstop. You make a decision now that if for any reason your power of attorney is insufficient or the persons that you might have wanted to act can't, then in this document, you're stating, this is who should be in charge of my person, my physical health, my living arrangements, all of those things. And this is who should be in charge of my finances and property. It does not have to be the same person, can be two different people. But you should try to pick somebody who is young and healthy and could be around, and most of all, somebody that you trust. It's difficult sometimes to make these decisions. There is accountability under the law for both your attorney in fact under a power of attorney and your guardian in the court system. But as many people find out, once the money's gone, you can't necessarily get the money back, even if you get a judgment. So again, pick somebody trustworthy, pick somebody that has accountability to you. And I guess fundamentally pick somebody and put it in a writing. Yep.
Fantastic. Or at least somebody relatively young, I guess, is the
True.
designation.
There are no guarantees, I think, as we all know, but it's definitely not a good idea to pick a parent in some situations.
Right.
Just based on statistics. Yeah.
Fair enough. Do you recommend somebody if, let's say the person wanting the power of attorney and healthcare surrogacy documents does not have a spouse, is there a preference for anyone, or is there someone who can't serve in those roles?
So generally speaking, for any of those roles, the person needs to be over 18, not have been convicted of a felony, ideally not have been charged with a felony either, just from a personal perspective of your choice. And they can't have been convicted of abuse of an elderly person, whether financial or physical. Ideally, again, you want to make sure they haven't been charged with any type of abuse or violent crime either, or property crime. You can choose really anybody for these roles. Sometimes people like to choose an accountant for a financial empowerment, and sometimes they have friends who are in healthcare that they name as healthcare surrogates. The most important thing is just that the person will be available, because you're taking the time to name them. It's important to have a conversation with them to ask them whether they would be willing to do this. And then, basically make sure your choice is going to be worth making. But you can choose friends. They don't have to be Florida residents, although it is helpful. You can choose more than one person to act, although that is also presents difficulties if you have two healthcare surrogates, and they both have to agree. It can be very time consuming to track them both down and get consent. So we usually recommend prioritizing this person, and if they are not available, then this person. And then similarly, in a durable power of attorney, we've found that a lot of local banks will not readily accept joint attorneys in fact. So if you have two children and you were thinking, well, I'll just name them both to act together, or both of them and each can act independently, you may run into a lot of issues with local financial institutions. So we do recommend usually name a first choice and then a second choice if the first is unwilling or unable to act.
And I know you said don't provide these documents to the person you're appointing. Is there anyone you do recommend giving copies of these documents to? like financial institutions or
Sure.
anything like that?
It's really important that the attorney who prepares the documents keeps a copy and that you keep their information. That's a general practice, best practice. It's important that your healthcare provider know that you have a living will and know who your healthcare surrogates are. So we often will make extra copies of those documents for people to bring to keep in their file. It's also important to understand that if you hand those documents out, if you later make a change, you need to get the copies you handed out back. So that can be kind of an awkward conversation sometimes. So that is usually why we say don't go handing these out to everyone. Just keep your documents in a safe place where it's accessible to you, and tell your person, here's where you can find them, here's how you can get to them. But generally, I don't recommend putting a durable power of attorney on file with your bank or with anyone else until it's absolutely needed.
And do you recommend
The
keeping
minute the
them?
bank has,
So sorry.
I was going to say, the minute the bank or financial institution has that document, it's as if you handed it over to the person named in it. They
Okay.
will absolutely be granted access. Yeah.
Do you recommend keeping them in like a safety deposit box at the bank to keep them safe?
No, no, we don't. Generally speaking, bad things can happen on weekends, nights, holidays, and you're not going to be able to go get a bank manager to open up the bank. If your name is not on the safety deposit box, you're going to need a court order to get into it, and the document you need to get the court order is in the box. It can be a really long and frustrating process. So no, I usually recommend keep the documents somewhere safe, but accessible. I have clients who keep them in a desk drawer in their house, especially if they live alone. I have some that keep them in a drawer in their office. I have some that keep them in a gun safe where a child has not a child, but one of their children has the combination to get into the gun safe. There's all kinds of places, but the main thing is, for these documents in particular, you want to be able to access them anytime you go to a medical appointment, just in case. And if you go into the hospital, you definitely want to bring your living will. So make sure it's someplace you can just get to it easily. Yeah.
Fantastic. Okay, so it's been about a half an hour, about 25 minutes. So we're going to take a short break for everyone, and we're going to pause the recording now and then restart it in just a few minutes. We are back with Jessica McGrew of the McGrew Law Firm here in Tallahassee, Florida, and she is going to now discuss wills and other probate issues, and we thank her for being here.
Thank you. So wills are one of a type of document called testamentary documents. Wills are not the only option. There are other things, many, many different kinds of trusts that can be set up, including a revocable living trust, which is a very common estate plan in Florida now. But I'm going to give you just some basics about what do these things do, what do you need to think about when you're setting them up, and why it's important to not do this without talking to an attorney. In Florida, we have a pretty basic requirement that you have to be 18. You have to know the extent of what you own. So you have to be able to realize, oh, I own property, I have some bank accounts, and you have to know who you're related to that would ordinarily be the ones to inherit. They don't have to be the ones you want to inherit from you, but you have to be able to know who they are. So that's a basic test of, we call it testamentary capacity, which means, do you have the ability to sign a document like a will or a trust? So once you meet that test, on the day you sign, you can do whatever you want in your will or trust within reason, to make arrangements for what will happen to your property when you die. A will is not effective until your death. You can change it as many times as you want. and rip up all the old ones until the moment you die, and then it goes to court and goes through probate, generally speaking. I'll talk a little more about that in a minute. In your will, you want to make sure that you have disposed of all your property. So a lot of times a very simple will would be I leave everything to my spouse. If my spouse predeceases me, I leave everything to my children in equal shares. And we use the phrase per stirpes, meaning if a child predeceases you, their children take whatever their share would be. That's sort of the basic format. But like I said, your will can leave whatever you want to whomever you want. Just specify what it is. I leave my beach house to my church. I leave, my home to my best friend. That is a very interesting example, actually, because one of the major issues people have in wills is their homestead. In Florida, we have a lot of laws about whether you can leave your home to anyone at all. And if you do leave it to someone, what sort of protections go along with it? So this is where I say it's important to talk to an attorney. If you own real property that you live at, you've been there 6 months, and it is your legal homestead under the Florida Constitution, then you may be restricted. If you have minor children, if you're married, you may not be able to pass that along to anyone. The law may do that for you. But if you can pass it on, there are protections against the forced sale of your homestead to pay your debts. And those protections go along with your home depending on who you leave your home to. So if you leave your home to your spouse or your children that are grown, or a grandchild, or anyone that would inherit under the intestate laws, which is if you don't have a will, then whatever debts you have at your death will not be paid out of your homestead. That will pass along without any forced sale. Now, mortgages go with the home. Those are not escaped by death. And similarly, you might suspect taxes. So property taxes, any debt to the IRS would pass along to your person along with that home.
So what you're saying is in Florida, death, taxes, and homestead are inevitable.
Correct. Correct. Yes. And so we see that a lot. There's a lot of great cases out there and examples in media about people who may have multi-million-dollar judgments that come to Florida and buy multi-million-dollar mansions, and the judgments never get paid because they can't be paid from the homestead, and it'll pass at their death to their children without that judgment getting paid. So there's a lot of protections for that type of property. There is other property that will pass at your death exempt as well. So for example, a life insurance policy will go to the named beneficiary. If you have a 401k or an IRA, those will go to named beneficiaries that you need to have on file with the company or financial manager of those type of policies or accounts. Those things do not ordinarily pass under a will, and there are very good reasons why they should not pass under a will. You may have a compelling reason why you need it to pass under a will. Maybe there's some sort of control over the money that needs to be exerted after your death. You don't want a windfall to someone. So that's where it would make sense to talk to an attorney and potentially a tax professional to understand the full consequence of what leaving payable on death items to your estate or to your trust, what negative consequences could go along with that. So getting back to just sort of the simple idea of a will, again, any property that's in your own personal name at your death can be passed to your intended beneficiaries under a will. It has to be signed when you have capacity. It has to be witnessed and notarized, and there's other requirements under the law governing execution of that document. One of the things that we typically put in wills for people who have minor children is who would be the guardian of those minor children if the parent passed away, and if the other parent had either already passed away or died without making any provision for the care of the minor children. So that's a pretty typical provision that we'll put in. That can be a stumbling block for a lot of people in making a will, but we generally encourage you to just pick who you think will be best today in this very moment. If you change your mind, we can always do a codicil or execute a new will at any point during your life. And again, minor children are children who are under the age of 18. They need to have a legal guardian appointed to take care of them. They also, if they're inheriting more than $15,000 from you, will need to have a guardian over their property appointed. And so you can, again, just like we talked about with a pre-need designation for yourself, you can bifurcate those two responsibilities. So you could have two separate people. You could have one person who's in charge of the day-to-day care of your children, and then one person who's managing all of their assets and funds under a guardianship.
What if you have minor children that and you're like leaving to go out of town for a few weeks or so, and you want to make sure your parents or whoever's watching the children have the ability to take them to the doctor, to take them in for anything, really?
So we a lot of times we'll prepare just a medical authorization form that a parent gives permission, names the person, gives their address and contact information, and says they have the ability to obtain medical care and make medical decisions for those minor children who are also named with dates of birth during a specific time period. And that document is notarized and witnessed. And it's just a temporary use sort of document. It would not necessarily be sufficient to establish a guardianship if something terrible happened while you were out of town, but it should be sufficient for the child to obtain any medical care and for insurance to find that that care was authorized.
Okay.
So one other piece of making your will, just because you don't own real property doesn't mean that you don't have things that are valuable to you. You can still make a will to dispose of all of your personal effects. If you have certain items that you want to give to certain people, you can do that with a separate writing as long as it's mentioned in your will and your will is properly executed. So what do I mean by that? If you have a china set that your great grandmother gave you, if there's a piece of furniture that's been in the family for generations, your vehicles, your boats, your tractors, your firearms, all these things can be individually listed on a piece of paper. You have to describe the item and the intended beneficiary so that any stranger would be able to go in, find the item, and get it to the right person. So for example, if you have a teacup and saucer collection, you can't say, I leave 5 to my niece. You have to say which 5 and which niece, and they have to be identifiable.
Great.
And the last thing that we sometimes put in a will is if you have any specific wishes for the final disposition of your body, whether you've made arrangements for cremation or interment or burial, a lot of times those provisions are still placed in a will, even if it's not necessary. For one thing, if you don't have any close family members at your death, your personal representative named in your will be empowered to carry out whatever your final wishes are. So by virtue of the fact it's in your will and they're named as a personal representative in your will, they can sign any documents to carry out those wishes. Which brings me to personal representative. That's what we call the executor role in Florida. And the personal representative is in charge of getting your will carried out. Usually that involves a court proceeding called a probate. The will gets placed with the court. A judge will review it and determine whether it meets all the legal requirements to be carried out. And if so, then the person you've named as personal representative will gather all of your assets in your individual name, consolidate bank accounts into an estate account. They'll gather all your debts, pay your debts, and distribute the rest to your beneficiaries. They'll also carry out any instructions on that personal property memorandum. And when you're choosing your personal representative, it's important to know that under Florida law, they need to be over the age of 18, and they need to be related to you by blood or marriage if they live outside Florida. So if your best friend lives in Chicago but has no relational connection to you other than friendship, they cannot serve as your personal representative in Florida. It must be a Florida resident or someone who's related to you by blood or marriage if they live outside the state. Now, they don't have to live in the same county where the probate's going to be brought, but those are the only restrictions. Well, those are the preliminary starting points. They also cannot have been convicted of a felony. They can't have been convicted of elder abuse. And they cannot be otherwise disqualified from serving. So that would involve questions of capacity sometimes too. And they'll be in charge and they'll carry out your will. They don't have to be a beneficiary. They can just be a person that you trust to carry out your wishes.
Okay. I'm trying to think if I have any questions about wills. Do you recommend, even if somebody doesn't have much, maybe they just have their house, do you still recommend that they get a will? In what certain circumstances would you recommend somebody not have a will, let's say?
So I think it's always a good idea to have a will, just because it's a record of your wishes. If everything you own is jointly owned with your spouse, your will probably not be probated if you pass away first. It's the same thing if you own bank accounts with another person, if you own property as joint tenants with rights of survivorship. All of those things generally don't require a will to pass to your beneficiary. Sometimes if people have what would be a small estate, if they have just a bank account with a couple $1,000s in it, they'll make their bank account payable on death to an intended beneficiary. And no probate would be required for that, just the presentation of a death certificate. However, there's always the risk that something might happen to that beneficiary. They might pass away before you. So it's a good idea to just have a will as a backup, to make sure that you've kind of thought through and that basically nothing you own is going to go to some distant person under an intestate law that you might not have ever met or intended to have benefit from you.
Right.
But I think too, that's a good reason to meet with an attorney so you can really understand how you own things, if you have the right to pass them on to someone else or not. And then also understand what the consequences are. There's a lot of alternatives to probate that people use. There are deeds where you can say, I give myself my property for life, and when I die, it automatically goes to these people. And I've seen a lot more of those, but there are also big risks with those deeds, and it's important to understand those before you, sign away your property.
Okay. That I was going to ask you about Ladybird deeds, but you already covered it. And so the other question I have is, let's say that my property is that I've lived on my whole life is actually titled in my mom or my grandmother's names. Can I pass that in my will? And is it a problem that it's not titled in my name?
So no and yes, it is a problem. Your will only govern property that's in your name at your death. So even if you have lived there your whole life, the advice is usually get your name on that property. You've probably been paying the property taxes anyway. Go ahead and get that property title cleared so that at your death it can pass under your will. If you do not have a right in that property at your death, it will not necessarily pass under your will to anybody.
Okay. And have you seen other issues with property titled in like mom or grandma's names, especially following storms?
Sure. Only the person whose name is on the property is the insured. And so there's a lot of issues with insurance payouts coming in. You may file a claim, there may be real damage, there may be an adjuster, there may be a check, but there's nobody alive to sign that check. And so often that will trigger a probate because we need to get a living person on the title to that property. And I will say that, 2 years after a person passes away, any debts that they owed during their lifetime can no longer be enforced, with a very limited exception of the IRS, which I think we can all understand. The IRS just kind of has their own laws about what
They
they can
always
do.
get their money.
They definitely try, that's for sure. And there are limits on that, but generally speaking, if you have, a mother or grandmother's name on your property and they passed away a decade ago, a lot of times it can be very helpful to get that property probated. You can transfer it. If it was their homestead at their death, you still can try that route to say this was homestead and we want to get it transferred. But usually it's a summary administration. It's a shorter probate process. There's no creditors. And so it can take, sometimes in Leon County, we can get those done in less than 30 days. And most attorneys do those on a flat fee and it costs less than a full probate. So there is a big incentive to get that title. And if they left a lot of heirs, then it's also important to do this while all of those heirs are still alive, or as many of them as possible.
Okay, great. And what if, me and my spouse are on the property and my spouse passes away? Should I get it transferred to my name? Is that my name alone? Is that a big deal?
That is not a big deal to do. If you own property as husband and wife, whether it's real property like your home or lands, or whether it's a bank account, you can generally present a death certificate. And presenting for real property usually means you record that in the county where the property is owned jointly. And the deceased spouse's name will be removed from the property and you'll be the sole owner. And of course, my advice is at that point, make sure you have all your documents in order if you're the last man standing. You want to make sure somebody can access all that if you become incapacitated. And of course, you want to make provision for what will happen to the property when you pass away, because now it is all yours. Yeah.
Okay. Um, are there any other big issues surrounding these pre-death documents, advance directives documents, or anything regarding probate that you recommend people keep an eye out for, or definitely if they have this issue, they should go speak with an attorney, something along those lines?
I'll say a few things on that. It is very important, I think, to always talk to somebody who understands how this type of law works, an attorney who practices in this area, because general advice may not be the best advice for your particular facts. And what do I mean by that? Things like prenuptial agreements, antenuptial agreements, blended families, where perhaps you have adult children that you want to protect an inheritance for them, but you've remarried and you have this spouse now that will have rights under the law if you haven't taken any other measures. It can make the probate very messy and very complicated if you do not have a will in that situation. And sometimes even if you do, but it's not complete, it's not accurate. If you get divorced, you should be aware that any designation you've made in any of these documents will be nullified under Florida law. It'll be as if that person predeceased you, but your retirement accounts follow a different law. So you need to make sure to change those beneficiary forms for anything that would be governed under ERISA, because otherwise your ex will be inheriting your IRA, much to the chagrin of your current spouse probably, or your children. So those are important considerations. It's also important if you have someone in your family who has special needs, special medical needs, special emotional care needs, things, addiction, any issues like that, that concern you, you want to talk to the attorney about those things as well, because if they qualify for government benefits, an inheritance may boot them off. And so there's special planning that needs to be done for those situations. I'm trying to think if there's anything else. If you own property in other states, if you own timeshares, I mean, these are the big issues that can cause expensive probates.
Okay.
Yep.
How often do you recommend someone amend the documents or, you know, change around the beneficiaries, anything like that?
So I think when you're going through open enrollment at your job, it's a good time to make sure all your beneficiary designations are up to date. And then I would say, honestly, I try to have my clients look at their documents annually. Hey, at the end of the year, you're getting ready to start a new year. Has anything happened? Did anybody get married? Did anybody have a baby? One big issue we've seen in a lot of documents lately is naming grandchildren without the forethought that maybe some new grandchildren would be born. And so we have families where two siblings inherit a substantial amount of money and the other siblings get nothing because they were not contemplated.
Uh-oh.
So keep up with the births, keep up with the marriages, try to make long-term plans, for those contingencies. Yeah.
Fantastic. Well, thank you so much for your presentation and all of your valuable knowledge. I'm sure that hopefully everyone is going away a little bit more knowledgeable about the subject and hopefully ready to get their documents done and ensure that their financial and healthcare needs are taken care of.
Thank you so much. I appreciate the opportunity.